On December 15, 1791, the Bill of Rights was finally ratified by the states. These famous 10 amendments to the Constitution guaranteed the American people specific freedoms from government infringement. The First Amendment now famously protects the freedom of speech, press, assembly, and religion, as well as the right to petition to the government. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. Perhaps one of the most controversial provisions of the Bill of Rights is the freedom of speech.
You piss fuck cunt cocksucker motherfucker and tits.
What speech is protected under the First Amendment? What speech is not protected under the First Amendment? Over the years, the Supreme Court has decided the answers to these questions. With the evolution of the internet, television, among many other new media, it is the job of the Supreme Court to apply the words of the Founding Fathers to modern times. Rulings that no longer apply to the modern world may be overruled by later rulings. Even so, new questions are always arising under our new information-packed world. Sometimes a case that seems insignificant can find its way up to the Supreme Court, and subsequently have a huge impact on American history and society. Soon, we will begin to explore the history and evolution of free speech in American history, as decided by the Supreme Court. Let us begin with one of the first landmark Supreme Court decisions on free speech. It is 1919, and America is in the midst of World War I. A man called Schenck, the General Secretary of the Socialist Party, is distributing pamphlets urging men to resist the military draft. In lending tacit or silent consent to the conscription law, in neglecting to assert your rights, you are, whether knowingly or not, helping to condone and support a most infamous and insidious conspiracy to abridge and destroy the sacred and cherished rights of a free people. You are a citizen, not a subject. You delegate your power to the officer of the law to be used for your good and welfare, not against you. They are your servants, not your masters. Their wages come from the expenses of government, which you pay. Will you allow them to unjustly rule you? No power was delegated to send our citizens away to foreign shores to shoot up the people of other lands, no matter what may be their international or internal disputes. The pamphlet continues to urge draftees not to submit to intimidation by the government, and encourages them to peacefully petition to the government to repeal the Conscription Act. However, Schenck is arrested and convicted of conspiracy of violating the Espionage Act of 1917, which made it a crime to obstruct recruitment among potential draftees. Schenck appeals to the Supreme Court, arguing that his conviction violates his First Amendment right to free speech. The case is named Schenck v. United States. In a 9-0 decision, the Supreme Court upheld the constitutionality of Schenck's conviction. The unanimous decision argued that in wartime, wider restrictions on free speech were permitted than would be allowed during peacetime. When a nation is at war, many things that might be said in time of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. The court continued to establish the famous clear and present dangers test, holding that only words that immediately cause a disturbance that creates a clear and present danger can be subject to regulation by Congress. The most stringent protection of free speech would not protect a man from falsely shouting fire in a theater and causing a panic.
I don't think the outcome in Schenck was justified. You remember that in Schenck, the court actually upheld the convictions of Elizabeth Barrett and Charles Schenck. So even though Justice Holmes articulated this test, the clear and present danger test, which sounds as though it's speech protective, the court didn't actually apply that test in the case, and so it affirmed the convictions. And when you look closely at the record in the Schenck case, I don't think the conviction was justified. I don't think a jury could have concluded that these socialists posed a clear and present danger. Something to the effect that undoubtedly the government's power to restrict free speech is greater in times of war than in times of peace, but only because war brings greater dangers than peacetime, but that the test that gets applied is the same, a test of imminence or clear and present danger.
16 years later, in 1941, another major free speech case called Chaplinsky v. New Hampshire surfaced to the Supreme Court. Chaplinsky, a Jehovah's Witness, was distributing religious literature on the streets of Rochester, New Hampshire. Chaplinsky's rants that all religion was a quote, racket caused disturbed citizens to complain to City Marshal Bowring, and Chaplinsky was taken to the police station. On the way there, he insulted Bowring, calling him a goddamned racketeer and a damned fascist. For these insults, Chaplinsky was arrested under a state law for breaching the peace. In protest, Chaplinsky argued that the statute violated the entire First Amendment. On the other hand, New Hampshire pointed out that the law did not restrict freedom of speech because it only banned remarks that were likely to cause violence. This argument formed the crux of the problem for the Supreme Court. Could the government regulate speech if it was likely to incite a fight? In a unanimous 9-0 decision, the Supreme Court decided that it was a valid exercise of state power to forbid speech that would likely start a fight. We are unable to say that the limited scope of this statute, as thus construed, contravenes the constitutional right of free expression. It is a statute narrowly drawn and limited to define and punish specific conduct lying within the domain of state power, the use in a public place of words likely to cause a breach of the peace.
So I don't think the fighting words doctrine itself is all that relevant today. I think the real legacy and importance of the Chaplinsky case is the extent to which Chaplinsky recognized a categorical approach to the First Amendment. And by categorical approach, what I mean is that Chaplinsky said there are certain categories of speech that are simply unprotected, that are not within the realm of the First Amendment because they are of such slight social value as a step to truth that any value they have is outweighed by the government's interest in order and morality.
After struggling with the issue of balancing general welfare and the right to speak, the Supreme Court was forced to take on a more sordid issue. The year is 1973. Marvin Miller, a seller of pornography, decided to launch an advertising campaign for his business. He began mailing pornographic images to random citizens in California. However, most of the citizens who received the images did not want them, and when a mother and her small child saw the photos, they called the police. The police arrested Miller, who appealed the arrest. He argued that arresting him for mailing pornography would violate his First Amendment right to freedom of speech. This case became Miller v. California. In front of the court, Miller's lawyer argued that there were too many different interpretations of obscenity in pornography. Therefore, there could be no bright line or specific definition created to encompass all obscenity equally. However, California argued that individuals had a right not to be confronted with pornographic material in their own homes, and that it was in the state's interest to protect that right. In the majority opinion, Supreme Court Justice Warren Burger stated that not all forms of speech actually have societal value, and that not all forms of speech actually deserve protection. But implicit in the history of the First Amendment is the rejection of obscenity as utterly without redeeming social importance. The court created the Miller Standard to determine if explicit speech was constitutionally protected. If some speech appeals to the average person's sexual interests, depicts a specific form of sexual behavior in an offensive manner, and lacks any value to society, then that speech is not constitutionally protected. The creation of the Miller test created a bright line that could be used to determine if something is in fact obscene enough to be criminalized.
If you apply the Miller test in such a way that material on the internet could be prosecuted, by some conservative community, meaning that those publishers of that material have to take it off the internet and the rest of us don't get to see it, then it would sort of reduce the rest of the country to what is fit for that most conservative community.
But one of the prongs in the Miller test is community standards. And do I think community standards have changed? Yeah. Do I think that there's still a distinction between some community in one part of the country versus another community in a different part of the country? Sure, I do think that there's, I think we've all moved along the spectrum. I don't think we've all moved at the same rate or to the same place.
In 1989, Revolutionary Communist Party member Gregory Lee Johnson participated in a protest against Reagan administration policies. At the end of the Republican National Convention, Gregory Lee Johnson burned an American flag in front of the Dallas City Hall. While no one was injured by the burning flag, several people report being offended. Johnson was charged with desecration of a venerated object, convicted, sentenced to a year in prison, and fined $2,000. The prosecution stated that the flag is a national symbol of the United States, and as such creates a sense of national unity. Preserving this sense of unity through the flag is in the best interest of the United States. Johnson's lawyers claimed that Johnson's conduct was a form of free expression, and as such could not be criminalized without violating the First Amendment. In Judge Brennan's majority opinion, the court ultimately decided that because Johnson's act of flag burning coincided with the end of the Republican National Convention. It was an obvious form of political discussion, and as such could not be criminalized. And Johnson's expression of dissatisfaction with the federal government's policies also does not fall within the class of fighting words. The court ultimately voted 5-4 in favor of Johnson. As a result, the court's decision in Texas v. Johnson invalidated the flag desecration laws of 48 states. Despite the Supreme Court's opinion, support for the criminalization of flag burning remains strong. Every so often, a flag burning amendment comes to Congress, but is always narrowly defeated.
Mr. Speaker, yesterday, folks, to burn or desecrate it is an insult to those who have made the ultimate sacrifice to keep us safe and to those who helped build our great nation. It should be illegal, and this Congress should make it illegal by finally passing a constitutional amendment to ban the burning of a U.S. flag.
Texas v. Johnson was very controversial when it was decided, and is to some extent still controversial now.
Yes.
Do you think in retrospect that the decision was sound?
Given what I've said so far, what do you think I'm going to say?
Yes.
But why do you think symbolic speech applies under the same protections as, actions?
Because it's just as powerful.
Mhm.
Because, and in some cases, it's more powerful. What's more powerful? A 5-page, discussion of Nazi ideology or the swastika?
A similarly acrimonious issue the Supreme Court has been forced to deal with is that of campaign finance. In 2002, Congress passed the Bipartisan Campaign Reform Act, otherwise known as the BCRA. Part of the BCRA barred corporations and labor unions from using their general treasury funds to create electioneering communications. In early 2008, Citizens United, a conservative 501c4 organization, wanted to run ads for its documentary, Hillary the Movie, a movie critical of Hillary Clinton. The U.S. District of Columbia decided that the ads violated the BCRA, as they would have depicted Clinton negatively 30 days before a general election she could have been involved in. Citizens United appealed the case, stating that the ads were factual and politically unbiased. So began the case, Citizens United v. Federal Election Commission. During Supreme Court oral arguments, Citizens United argued that robust political dialogue is the most fundamental purpose of the First Amendment. However, by prohibiting corporations and unions from doing so in the critical periods before an election, the BCRA prohibits political speech when needed most. Citizens United also held that spending by corporations and unions constitutes an independent expenditure by that organization, meaning the organization is running its own ad campaign in favor of a candidate, rather than contributing money directly to a candidate. Because independent expenditures do not involve giving money to an elected official, they cannot cause corruption, and as such cannot be criminalized to promote general welfare. Finally, Citizens United argued that allowing the government to criminalize speech based simply on who said it would result in the government being able to prohibit books simply because they are written by a union or corporation member, potentially leading to gross abuses of power. The FEC, on the other hand, argued that allowing corporations to spend money in U.S. elections would lead to foreign corporations being able to create U.S. subsidiaries through which they could spend money to influence the U.S. elections. The FEC also maintained that the First Amendment only applies to individuals, and that the Supreme Court does have a long history of holding corporations to different standards than individuals. Finally, the FEC pointed out that should corporations use their general treasury funds in political advocacy, they will be using the funds of shareholders who do not necessarily agree with their views, thereby distorting the speech of others. The Supreme Court decided that preventing the loss of political speech was the most important issue to be considered, as political speech was the primary form of speech protected by the First Amendment. Because spending money on advertisements is a method of speech, and because political speech is necessary for a functioning democracy, the U.S. government cannot ban spending money.
Be prepared for the little changes, too. If there are any small towns left to take over, Walmart can now soften them up with carpet advertising for their Walmart Town Council candidates, brought to you by Walmart. Be prepared for the Richard Mellon scapes to drop such inefficiencies as vanity newspapers and simply buy and install their own city governments in the Pittsburghs. Be prepared for the personally wealthy men like John Kerry to become the paupers of the Senate.
One of the consequences is these corporations have a lot of money that, again, bears no relation to the public support of its views. And those corporations can use that money to distort the political process. And that's what the court recognized in Austin, that corporate spending on candidate elections has a corrupting influence on the political process. Not corruption in the old-fashioned quid pro quo sense, not in the sense of, oh, I'm going to give you $1 million for your campaign if you vote for this legislation or you do me this favor, but in the sense that corporations are disproportionately dictating the political conversation and who gets elected.
Therefore, the freedom of speech as protected by the First Amendment has had a long and controversial history. As the times have changed, so has the application of the First Amendment by the Supreme Court. From times of war to violent video games, there will always be questions arising from the murky legal distinctions between protected and unprotected types of free speech. However, one thing will always stay the same: the Supreme Court will always have the last say.